Our founders did not create a nation under which we Americans who had just fought a desperate 8-year war to escape the tyranny of Britain, that we would live under a tyranny of bureaucrats unaccountable to our political will. Absolute madness. Back to Trump's email firing. President writes, in my judgment, the National Labor Relations Board is not presently fulfilling its responsibilities to the American people. The NLRB wields immense executive power over private employment relationships and relations with unions, an area with vast economic consequences. The aims and purposes of the administration, the Trump administration, sworn in a week prior to this, with respect to the work on the NLRB, can be carried out most effectively with personnel of my own selection. To that end, effective as of this date, Gwynne A. Wilcox is removed from the office of members of the NLRB. In addition, these two board members, including Wilcox, have not, in my judgment, been operating in a manner consistent with the objectives of my administration. In my judgment, members Wilcox have adopted a host of decisions that have improperly constrained employers' rights to speak on the subject of unionization, raising serious First Amendment concerns about the censorship of important speech. Several such decisions were issued on the eve of the new administration. In other words, they knew Trump was elected, and they were still issuing orders they knew he would not approve. That is insurrection of the executive authority of the Article 2 branch of government. Trump continues, the country is eager to get to work, revitalize our economy, and operate under clear, predictable rules that are fair to employers, unions, and employees alike. I lack confidence that Commissioner Wilcox will faithfully execute those objectives. Again, she was appointed by Biden. And there's an important footnote here, too. Footnote. While the National Labor Relations Act purports to limit removal of board members to, quote, neglect of duty or malfeasance in office, but for no other cause, so conditions for termination, Trump writes, this limitation is inconsistent with the vesting of the executive power in the president, the constitutional vesting of the executive power in the president, and his constitutional duty to take care that the laws are faithfully executed, and thus does not operate as a restriction on my ability to fire board members. What do you think is the greater authority, folks? The National Labor Relations Act passed by Congress and some preceding president, or the U.S. Constitution? The answer should be clear, but apparently a bunch of federal judges, including 3 Supreme Court justices, can't figure it out. And then they quote a recent Supreme Court decision. We'll talk about it in a bit. Sela law. It's from 2020, only 5 years ago, in which the Supreme Court held, controlling president, quote, as a general matter, the Constitution gives the president the authority to remove those who assist him in carrying out his duties, his executive duties. And Trump notes the NLRB exercises core and plenary, I would say, executive powers. You cannot compel the Article 2 executive branch president elected by the whole of the American people to carry out our political will. You cannot compel him to delegate his executive power to people not only not of his choosing, but politically opposed to his agenda, the agenda we elected him to carry out. It would be madness. That's here. All that happened January 27th/28 is when Wilcox received this email. And she initially put out a press release that said, hey, it's been great working here, but I'm fired. Well, that didn't last too long. I guess the progressive woke DEI mind virus lawyers got a hold of her a few days later. And on February 5th, they filed a complaint in federal court claiming that her termination was unlawful and that the president should be compelled to delegate his executive authority under the Constitution to someone not of his choosing and who's politically opposed to his agenda. On its face, it's an insanely unconstitutional argument. But guess who bought it? Unelected, black-robed, tyrannical, inferior federal district trial court judge out of the District of D.C., Beryl Howell. Not only did she buy the argument, not only did they didn't even ask her for a temporary restraining order or a preliminary injunction. On March 6th, Judge Howell grants summary judgment ordering Wilcox be put back into office. Summary judgment. That means no trial, no legal argument. Judge Beryl Howell said there's no facts in dispute. The law, in her view, is clear. I have the authority to compel the president to delegate his executive power to his political enemies. That's what Judge Beryl Howell believes the Constitution says. Only took her a couple pages to write all that out. Let's take a look at that. This is her March 6th order. Judge Beryl Howell, upon consideration of Gwynne Wilcox's motion for summary judgment, meaning there is no trial, there is no jury, there is no argument, there are no instructions to the jury, that doesn't exist. The judge decides. Judge Beryl Howell, unelected, black-robed, tyrannical, inferior federal trial court judge Beryl Howell makes this decision. Ordering around the Article II executive branch President Trump, who we elected to carry out our political will, ordering him around as if he were a clerk in her court. Upon consideration of Gwynne Wilcox's motion for summary judgment, it is hereby ordered that Gwynne Wilcox's motion for summary judgment is granted. That the White House motion for summary judgment is denied. And that the termination of Gwynne Wilcox was unlawful in violation of the National Labor Relations Act and is therefore null and void. So on March 6th, Judge Beryl Howell declares Trump's firing of Wilcox, a subordinate, was unlawful. Interesting that yesterday the Supreme Court decided this order by this judge was unlawful. How you like them apples, Judge Howell? Further declared that the termination of Gwynne Wilcox was unlawful and is therefore null and void. Further declared that Gwynne Wilcox remains a member of the NLRB and may be removed by the president only upon notice and hearing for neglect of duty or malfeasance in office, but no other cause, citing the congressional statute there, as if Congress has the authority to constrain the executive power of the president, except as explicitly stated in the Constitution. Ordered that Gwynne Wilcox shall continue to serve as a member of the NLRB. Ordered that the Trump administration are enjoined, prohibited from removing her from her office, or in any way treating her as having been removed from office, impeding in any way her ability to fulfill her duties, or denying or obstructing her authority or access to any benefits or resources. Further ordered that the Trump administration provide Gwynne Wilcox with access to necessary government facilities and equipment so that she may carry out her duties during her term as a member of the NLRB. So let's be clear about what's happening here. She is being put back in office. Trump is being compelled by this inferior, black-robed, tyrannical, unelected federal judge. Trump is being compelled by her to delegate his executive authority bestowed by the Constitution exclusively in his hands, compelled by this judge to submit to the court's will and delegate that authority to someone not only not of his choosing, but his political enemy. That happened on March 6th. Well, Trump says, I'm going to follow the legal process. And he went to the Court of Appeals. Case gets randomly assigned to a 3-judge panel of Court of Appeals judges in the District of Columbia. And they look at this and they say, wait a minute, this doesn't make any sense. We're going to stay. It says here, stay injunction. We're going to stay the summary judgment. So Trump had fired Wilcox on January 27th. A couple of weeks later, Beryl Howell puts her back in office. So now she's back. A couple of weeks after that, the Court of Appeals stays her order. So Wilcox is fired again. This is madness. And by the way, if it turns out that Gwynne Wilcox being put back in office by Judge Howell, that was unlawful, everything that Wilcox did when she was put back in office is itself unlawful. Every decision, every ruling, every exercise of executive authority was without legal effect. Imagine the chaos this is causing among the people appearing before the National Labor Relations Board. They have no idea if the person they're arguing before, Gwynne Wilcox, actually has legal authority to be there or not. Insane. And to the Court of Appeals, by the way, when Gwynne Wilcox, let me rewind a step. When she was put back in office on March 6th, look how the media covered this. Look at the sad-faced Trump. Breaking. A federal judge ruled that Donald Trump's firing of Gwynne Wilcox from the National Labor Relations Board was an illegal act and a blatant violation of the law. U.S. District Judge Beryl Howell condemned Trump's action, stating the president's excuse for his illegal act cannot be sustained. This is Beryl Howell going back to her office, having been reinstated, delegated executive authority at the order of a judge rather than at the discretion of our elected Article 2 executive branch president. This is how happy she was and her staff. Look how happy we are that we're undermining the constitutional order of our nation. Under what authority? Under what authority? These are jobs that exist for the job itself. There's more here. We got a little bullhorn. The media is there. Look, we defeated Trump. We defeated the Constitution. Congratulations. Absolute congratulations. So then we have the Court of Appeals. Trump appeals like he's supposed to Judge Beryl Howell's bosses. Gets randomly assigned to a 3-judge panel. And that panel says, wait a minute. This isn't right. This isn't right. Let's see what they have to say. Here's the decision of that 3-judge panel. Filed on March 28th. The motion to stay the summary judgment is granted. Let's see what their rationale is here. Well, it starts with a fundamental constitutional principle. Article 2 of the Constitution vests the executive power in a president of the United States and requires him to take care that the laws be faithfully executed. Sound familiar? Anybody? To protect individual liberty, the framers created a president independent of the legislative branch. So these congressional conditions for firing cannot stand. They're an unlawful violation of the separation of powers doctrine. The Constitution does not give Congress the authority to constrain the Article 2 executive branch president from firing people within the executive branch. To further safeguard liberty, the framers insisted upon accountability for the exercise of executive power. Gwynne Wilcox is exercising executive power. Trump was compelled by Judge Howell to delegate to her. How is there any accountability? I mean, we can hold Trump accountable, but we can't hold Trump accountable for what a judge orders him to do. And we can't hold the judge accountable. She has a lifetime appointment, never elected in the first place. The framers insisted upon accountability for the exercise of executive power, so they lodged full responsibility for executive power in a president who is elected by and accountable to the people. Executive branch agencies do not disrupt that design when they are accountable to the president. But consent of the government is a sham if an administrative agency by design does not meaningfully answer for its policies to either of the elected branches of government. That's why the Supreme Court has said that Congress cannot restrict the president's removal authority over agencies that wield substantial executive power. And that's the decision of Seal of Law that I mentioned earlier. The Supreme Court's precedents control this court's case. Under those precedents, the government is likely to succeed in showing that the statutory removal protections for the NLRB and Cathy Harris at the Merit Systems Protection Board, also fired, are unconstitutional. The government has also shown that it will suffer irreparable harm each day the president is deprived of the ability to control the executive branch. You know, if you or I, normal American citizens, were to go to federal court and claim a violation of our constitutional rights, a government official is constraining our First Amendment rights, for example, the courts consider any infringement of a constitutional right, no matter how minor or transient, to be by definition irreparable harm. How can it not be irreparable harm to have an entire branch of government, the Article 2 executive branch of government, subjugated to the political will of an unelected, black-robed, tyrannical, inferior federal trial court judge like Beryl Howell? Of course, each instant that's happening, it's a violation of the separation of powers doctrine. It's an insurrection by an unelected judge against the authority of the elected executive branch president. Of course, it's irreparable harm. Every microsecond that's happening is irreparable harm to our nation, to our constitutional order. Conversely, writes this three-judge Court of Appeals panel, the removed officials suffer no cognizable irreparable harm, nor do the agencies for which they worked until they were fired, because what's their harm? And this is going to come up later. We're going to talk about this. What's the harm suffered by these people? The cognizable harm. Well, I guess it's their loss of income. So if they think they were wrongfully terminated, they could file a wrongful termination claim, ironically enough, in the Merit Systems Protection Board agency, of which Cathy Harris was the head until Trump fired her. Like, she should know better than anybody. If you feel you work for the federal government and you've been wrongfully terminated, Congress has stripped authority over that dispute from the unelected, black-robed, tyrannical, inferior federal district trial court judges. They do not have jurisdiction over federal employment disputes. Congress stripped that away from the courts and instead put it in this administrative agency, the Merit Service Protection Board. One of the people involved in this dispute is Cathy Harris, who was the head of the Merit Service Protection Board. She knows this, went to federal court anyway, found a favorable judge in the District of Columbia, district courts. But they're not suffering irreparable harm, because if they feel they were wrongfully terminated and the MSPB agrees, they can get back pay. They can be made financially whole. What they don't have is they do not have any independent authority to those jobs. That's determined by the elected Article 2 executive branch president. So you can get the back pay, maybe. If you can prove you were wrongfully terminated, you may be entitled to back pay. What you cannot do is compel the elected Article 2 executive branch president to delegate his executive authority against his will. The very notion is insane. The people elected the president to enforce the nation's laws, and a stay of the summary judgment serves that purpose by allowing the people's chosen officer to control the executive branch. I'm not going to read the rest of this. We've covered it kind of before. But guess what happened then? Guess what happened then? The Court of Appeals says, no, we're going to stay the summary judgment. The executive branch president has to control the executive branch. That's just the way it is. And every moment a inferior federal district trial court judge is impeding that executive authority, it's a violation of our constitutional order and irreparable harm to our government. Well, then Gwynne Wilcox asked for and received within a couple of weeks, 10 days, an en banc Court of Appeal hearing. So in the District of Columbia, on the Court of Appeals, there's 10 or 12 or 15 judges on the Court of Appeals. They're randomly assigned in 3-judge panels to hear cases, like was heard on March 28th, like we just looked at. A 3-judge panel, randomly assigned, they hear it. That 3-judge panel said, no, we're stopping this summary judgment by this Judge Beryl Howell. We're stopping it. And Gwynne Wilcox then said, well, I'd like to have an en banc Court of Appeals hearing. En banc is when all 10 or 12 or 15 Court of Appeals judges agree to rehear the argument. We're gonna set aside the 3-judge panel decision, our peers, our colleagues, and we're gonna rehear it as a larger group. Well, the District of Columbia, of course, is a bunch of progressive woke DEI asshats. It's just that Trump got lucky with his 3-judge panel. So when they heard it en banc, they reversed the stay of the summary judgment, and Wilcox is now back in office. Look at it. January 27th, she's out of office. March 6th, she's back in office. March 28th, she's out of office. April 7th, she's back in office. This is why judges are not supposed to be exerting executive authority over the government. This is why it's bizarre, the pace of these events in the federal courts. Anyone who's ever worked in the federal courts knows that they work with painstaking slowness unless they're politically energized. So the en banc court does its thing, says, no, they're back. They're back. She's back. She's back in office. Let's take a quick look at what they had to say. Whoops. That was not the thing I wanted to do. This is the thing I wanted to do. April 7th. En banc. So before it was a 3-judge panel, now it's all these judges. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 of them. Upon consideration of the petitions for hearing en banc, which includes motions for en banc reconsideration and vacature of the 3-judge panel that refired Wilcox, it is ordered that the motions for an en banc reconsideration and vacature be granted and the government's motion for a stay pending appeal be denied. So Wilcox is back in office. Now, they mention a couple cases here that they claim support their position. In Humphrey's Executor and Wiener, the Supreme Court unanimously upheld removal restrictions for government officials on multi-member adjudicatory boards, which the National Labor Relations Board is. So there's something about these two decisions because it's conflating intellectually, dishonestly, conflating two different issues that I've already touched upon. One is, might a fired executive branch official be entitled to back pay? Might their termination, in fact, have been unlawful? The answer is yes. It's theoretically possible. And the remedy would be back pay. That is a completely different question under our constitutional order than whether a judge, an unelected, black-robed, tyrannical, inferior federal district trial court judge, can order the elected Article 2 executive branch president to delegate his executive authority bestowed entirely by the Constitution upon that one individual, the president, whether that unelected federal trial court judge can compel the president to delegate his authority to someone not of his choosing and a political enemy. Back pay is one issue. Compelling the president to delegate his authority against his will is a completely different issue. And the truth is, nobody cares about the back pay. Nobody. I mean, maybe the person who's getting the money, but the back pay is not an issue of constitutional import. It doesn't affect how our government functions. It doesn't denigrate the constitutional order our founders established for us. It's just money. Nobody cares about the money. What we care about, or should care about, what I certainly care about, is the compelled delegation of executive authority from the president to someone not of his choosing and a political enemy. That does undermine our constitutional order. So this en banc panel of the Court of Appeals says, no, we're putting Wilcox back into office against the president's will, against the will of the elected Article 2 executive branch president. And we're basing that decision to compel him to delegate his executive authority against his will on these two cases, Humphreys and Weiner. Let me ask you, do you think that Humphreys and Weiner actually stand for the proposition that the Article 2 executive branch president can be compelled to delegate his authority against his will? Because remember, Wilcox is not just being given, she's not being given back pay. She's ordered returned to her office. And Trump is prohibited from interfering with her exercise of his executive authority. That's what the court ordered here, not back pay. Is that what Humphreys and Weiner held? You would think so, watching this. Because this en banc Court of Appeal says, yes, we're putting her back into her office on the basis of Supreme Court decisions, Humphreys executor and Weiner. Well, let's take a look at Humphreys executor, shall we? Let's take a look. What was Humphreys executor about? Was it about compelling the president to delegate his executive authority against his will? Humphreys executor, by the way, Humphreys was dead. He died. That's why it's his executor. What is this case about? The plaintiff, his estate, brought suit in the Court of Claims against the U.S. to recover a sum of money allegedly due to the deceased for salary as a federal trade commissioner when the president undertook to remove him from office. So President Roosevelt here had fired Humphrey. Humphrey believed his firing was wrongful. He sued for monetary compensation for his back pay. Then he died, and his estate maintained the suit. And it got up to the Supreme Court. And the Supreme Court said, yeah, you got to pay him. That's monetary compensation. What did the Supreme Court not say here? They did not say that a court, even the Supreme Court, can compel the Article 2 executive branch president to delegate his authority against his will. All Humphrey said was the guy's entitled to back pay, which was paid. That's Humphreys, not a compelled delegation of Article 2 executive branch authority. What about Weiner? You think Weiner was about a court, even the Supreme Court, compelling the Article 2 executive branch president to delegate his authority against his will to someone not of his choosing, to a political enemy? You think that's what Weiner was about? These courts are such despicable liars because they know that a lay audience doesn't know this stuff. They know most lawyers are not going to bother looking at the cases. I mean, just look how they present it. This is our authority for ordering Trump to give Wilcox her executive authority back against his will. Humphrey's executor and Weiner. Whoa, I guess if we go read those cases, that's what they mean, that Trump can be compelled to delegate his executive authority. We just saw Humphreys didn't do that. What about Weiner? Weiner's a more recent case, 1958. Humphreys, by the way, was from 1935, the depths of the New Deal, from which a lot of political feces was excreted. But now we're in 1958, just after World War II. What was this case about? Weiner. First sentence. This is a suit. Sorry, here's Weiner, 1958. First sentence of the decision. This is a suit for back pay based on petitioner's alleged illegal removal as a member of the War Claims Commission. Was Weiner asking that an unelected black-robed, tyrannical, inferior district trial court judge compel the Article 2 executive branch president to delegate his authority under the Constitution against his will? No. It would never have occurred to Weiner to do that. And the Supreme Court doesn't hold that here. The Supreme Court merely says, if this guy was wrongfully fired, he may be entitled to back pay, to money, not to constitutional authority. However much you think you hate these progressive woke DEI mind virus judges, it's not enough. It's not enough. They know what these cases really mean. They know. They're just lying to you. They're deceiving you. These are high crimes and misdemeanor against our constitutional order. This is insurrection against the Article 2 branch of government. Absolutely contemptible. Now, there was a dissent here. I'm not going to read it. Obviously, the three judges who wrote two of the three judges who wrote the original decision, but the large majority of these 11 or 12 judges here, everyone who participated in this majority opinion should be impeached and removed from office. They know damn well what they're doing is wrong. They know. That was April 7th. Wilcox is now back in office. Out of office, back in office. Out of office, back in office. And that brings us to yesterday. SCOTUS. Supreme Court decision, 6-3. Trump has the authority to fire Gwynne Wilcox from the NLRB. That's the decision we're going to look at right now. So she's fired again. Fired, rehired. Fired, rehired, fired again. It took 4 months for the Supreme Court to arrive at the obviously correct constitutional answer to this question. Obviously correct. Despite this judge, Beryl Howell, despite her declaration that Trump acted unlawfully 4 months earlier, the Supreme Court came around yesterday and said, no, the person who acted unlawfully was Judge Beryl Howell. That was the unlawful order. And the en banc Court of Appeals for the District of Columbia, their order was unlawful. The lawful position, the constitutionally sound position, the elected Article 2 executive branch president obviously has the authority to fire executive branch personnel.
Thanks for watching this highlight segment of our full-length Law of Self-Defense live stream.
If you enjoyed this content, make sure to give us a like and subscribe for more expert analysis on politics, law, and how to be hard to convict. And to watch the full-length episode of this show, just click right here. Stay safe.